Hi, my name's Andy Siegel. I'm an attorney here in Madison County, Alabama. Right now I want to talk about what happens when a juvenile has been convicted of a sexual offense. And specifically what I want to talk about is, do the laws requiring registration as a sex offender apply? The answer is that for a juvenile who is 14 years old or older, those laws do apply to some degree, but a little bit differently than for an adult. First thing is, what was the juvenile found to have, what criminal offense, what sexual criminal offense was it that the juvenile was found to have committed? If the offense was one of the most serious juvenile sexual offenses or sexual offenses such as rape first or sodomy first, then that registration is pretty much like for an adult. It is a lifetime registration. However, after 25 years, the juvenile can petition, that is, they can ask to be removed from the registry. It's a long time. The other type of registration is for less serious sexual offenses, and that would be a period of 10 years, and that is 10 years from when they complete any, and they have to successfully complete any kind of counseling or treatment. And so for those juveniles, it would apply for 10 years. Thus, if you had a fellow who completed their counseling at 15, they would still be registered, but it would be until they were 25. Obviously, the best thing is if you have a juvenile who is charged with something like that, the only way of completely avoiding that is if the case was somehow either a not guilty or a dismissal. If you have a child who's accused of something like this, or if you're accused of something like this as a juvenile, you really need to seek counsel as quickly as you can. Feel free to give us a call if you want at Siegel & Siegel. Our telephone number is 256-533-4529. Hi, I'm attorney Andy Siegel, and today I want to talk about, in juvenile cases, whether the juvenile sexual cases, whether or not the Alabama sex offender notification laws apply and how they apply. The answer to that is that when a juvenile has been convicted of a sexual offense and ordered to some sort of treatment, which will always happen if they're convicted of a sexual offense, at the conclusion of their treatment, whoever is providing the treatment is required to provide a risk assessment to the court. And that risk assessment will provide the judge with an opinion by that treatment provider as to whether or not that person is a low, medium, or high risk of reoffense and danger to the community. The judge, based on that information, will make a decision as to what level of notification applies. If, for example, the judge determines that the person is a low risk, then the notification may be only to people, kind of a need to know, people in the school who would have to know, and it'd be a very limited disclosure. If the person is a high risk, then the regular notification that would be required of an adult may apply. At any rate, the best circumstance for somebody who's accused of a sexual crime is to avoid that. The only way of avoiding that is to either be found not guilty or have the case dismissed. Whatever the circumstances, if it's a juvenile who's accused of a sexual offense, they really need to seek counsel as quickly as possible. Feel free to call us if you want. Again, I'm Andy Siegel of Siegel & Siegel. Thank you.